I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining about it.
Alright guys, today we've got possibly the dumbest sovereign citizen I've ever seen. And that's saying a lot. Somehow, in 2025, these people still walk among us. This guy can't even read, yet he thinks he can stroll into court and defend himself like he's some legal mastermind. And his main argument, brace yourself. He says he's not getting a fair trial because he's only had 1 hour to study the law, while the prosecutor had 7 years in law school. Like, bro, that's like showing up to the Olympics with 0 training and then complaining the gold medalists had more practice. You cannot make this stuff up. This one's going to be painful to watch, but also hilarious. Drop your thoughts in the comments as we go, and let's dive in to watch this guy get absolutely wrecked by reality.
People of the state of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I would leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of freedom of speech and the rules of professional conduct, I'd like to read my motions.
My goodness. This man can barely read, and yet here he is, standing in court, trying to read his own motions like he's some kind of legal prodigy. Be honest, what's his reading level? I'm thinking maybe 6th grade. And that's me being generous. But here's the kicker. He's actually complaining he hasn't had enough time to study the law. Like, sir, do you honestly think the judge is going to hit pause on your case for the next 7 years so you can go to law school? The entitlement is unreal. Back in my day, if you didn't know how to do something, you found someone who did. You didn't throw a tantrum and expect the whole world to bend over backwards for you. The court's already given him options. Hire a lawyer, take a public defender, or represent yourself if you actually know what you're talking about. Spoiler alert, he doesn't. What's next? Is he going to ask for a delay so he can get sworn in as a Supreme Court justice? Let's dive back in and watch this train wreck unfold.
All right, go right ahead.
for every waste of time and the more money of the people and their state. I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study even after motion, or the judge throughout plea not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court, and for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out, and when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on, and I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are U.S. Supreme Court, Michigan rules. And
anybody else just waiting for the judge to hit him with? Good speech, little guy. Motion denied. Because honestly, that's exactly where this is going. This dude really didn't have to read his motion like he was delivering the Gettysburg Address. I'm convinced the only reason the judge let him finish was for the entertainment value. Like, sure, champ, go ahead. Let's all have a good laugh. And that's probably the only reason she didn't shut him down right away. Judges have the power to toss out ridiculous motions on the spot, especially when they're blatant time wasters like this one. Rule 11 of the Federal Rules of Civil Procedure literally exists for situations exactly like this, to stop people from clogging the system with nonsense. Courts can, and will, hit you with sanctions for filing baseless garbage like this. But hey, maybe he thinks if he talks long enough, the judge will suddenly be struck by his sovereign wisdom and toss out the case. Spoiler alert. That's not happening.
Impartial trial, miscarriage, also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws to that. If we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
Your Honor, that's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial.
Is this guy playing dumb? Or is he genuinely this clueless? I'm leaning toward playing dumb because there's no way someone could be this oblivious while staring down actual jail time. This isn't a high school pop quiz. You don't just wing it and hope for the best. His entire defense collapses the moment you remember he could have had a court-appointed attorney for free, but nope. Instead of taking free legal help, he's out here clogging the system with nonsense motions and whining about only having 1 hour to study for court. Like, what did he think this was? An open book test? This guy is the human version of that one kid in class who didn't do a lick of research for his presentation. So he just starts making stuff up and hoping nobody notices. Newsflash, we all notice. School.
And it states that as a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that, and you didn't want that either. So then we went through the hearings, and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
I made my findings. You are able to appeal anything you wish.
You gave me bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's
That's right.
another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and you have some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you.
Perfectly handled. This judge played it like a pro. Sure, she could have shut him down faster, but then again, we wouldn't have gotten such premium grade comedy out of it. Seriously, what was going through this guy's head when he strolled into court today? Did he actually think he was going to finesse his way to victory when he could barely stumble through that crumpled up piece of paper he probably found on the jail floor? And this right here is why knowing your rights actually matters. Not so you can spew some made-up sovereign citizen fairy tale, but so you don't end up like this guy, embarrassing yourself in front of a judge who has zero patience. 4 games. Let's be real, courts don't play with this kind of nonsense. Even with a chill judge, your motion is DOA when you've got free legal representation standing by, and you still decide to DIY your defense. Makes absolutely no sense. Honestly, this might be one of the dumbest legal arguments I've ever heard in my life. The law isn't a choose-your-own-adventure book where you get to make up the rules as you go. But hey, at least he gave us some top-tier entertainment. If I had to rate him, reading level, 3rd grade, 6th grade was me being way too generous earlier. Anyway, let me know in the comments if you agree. And if you've got other courtroom disasters you want me to roast, drop them below. I post daily, so there's always room for more chaos. Thanks for watching, you legends, take care, and I'll see you in the next one.